Hi, my name is Emily Kyle. Thank you for joining me. So, the question today is, how do I name a successor guardian? So, it's a great question. So, the first thing is in Arizona, we don't have backup guardians appointed by the court. So, if you go to court to be appointed as the guardian of somebody and you have a second guardian, they have all the same rights and responsibilities that you do. And that guardianship should be set up with co guardians to say that either you can act independently, which would be my suggestion, or that you have to act jointly. But they're not a backup. They still have, as I said, all the same rights and responsibilities. So if you want to name a backup guardian, so if the bad thing happened to you suddenly and you didn't have time to get a co guardian appointed or nominate somebody for that role, you can do that in a separate document called a nomination of guardian. Requires two witnesses and a notary. And you can list as many people as you want or entities, licensed fiduciaries, whomever, to be the successor guardian. The process for that is the bad thing happens to you, the nominated person would take that form along with either a physician report saying you're incapacitated or your death certificate and submit that to the court with a couple of court documents. And the clerk should then issue letters to that person, letters of guardianship, so that they're appointed either immediately or within a day or two. So there's no gap in time. And then that person has to go through all of the formal steps to be nominated or to be appointed as guardian. Have a hearing, court investigator, fill out all the court forms, the affidavit, all of that needs to happen, and notice provided to all of the parties. The other option is you can nominate a successor guardian in your last will and testament. So you can have a section in there that says if the bad thing happens to me, then these are the nominated guardians. The slight downside of that is the will has to be submitted to the court and they're going to keep the original. And typically you would only have one original. So if you had to do a probate also, hopefully you would submit those at the same time. We like to do them in both places, a separate nomination and also in the will, just in case something got lost. Really important to make sure those documents get updated, though. If things change and you nominated people that you don't want to be the guardian any longer, or they're not available, they're a bad choice, they're not with us anymore, whatever that might be. So just like your other estate planning documents, keep it up to date, make sure people know where to find the document, who are the nominated people. So I hope that was helpful. If you have other questions, please shoot us an email or give us a call. We'll try to answer them for you. Thank you so much. Have a great day.